Item 1, PRDB 3 of 2024. Appearing for
We have dismissed the appeal.
Blair. Item number 2, PRS 7
2021, not 2022, it's 2021, isn't it?
31.
Yes.
From SLSA. Only for
Oh, you have been appointed. That's the reason why we kept it as to be mentioned today.
yes, I engaged like a SLC, but no, who is the affected?
Oh, who is the appellant? You are for the victim, right?
I'm for the woman. He is for the other.
Where is the appeal? The memorandum?
Last stage.
Hmm.
Shubham Majumdar, full appellant.
Oh, you are the appellant.
Oxford.
Have you got in touch with the victim?
I have received the engagement letter, but no case file was received.
Oh,
So I prefer that. And next week I prepare it.
let him come prepared because he's just received the appointment. Mr. So-and-so appears before this court and submits that he has received an appointment letter from the SLSA for representing the appellant in the present matter. Learned Counsel submits that he has not received the case file. Paragraph in view of the above, comma, the matter be placed before the next available circuit bench.
I will. Public. Item 3, WPA T 11 of 2021. That's matter taken to litigation.
Yes, 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 yes.
Not they were directed to. We have prepared a short report not so that the matter can be appraised before this court.
Yes, yes.
Not,
Please serve a copy.
let it be passed over and go through the report in the meantime.
Well, or you want a passover?
Pass over.
Well.
There are two matters, but just.
Well, faster.
Vijay. We have a copy.
Well, I'm paying for the petitioner.
Yes.
Yeah, is supposed to file their appeal.
You are appearing?
And we have not by the good. There is no release claim against us.
So you don't want to file an affidavit, right? So we'll record that.
There is an order of the court, whereby directed them to say why they can't accommodate this. There is an order passed by my lord. Justice.
So if they do not intend to file, the order still remains.
Yes, because
Order
there is an
still-
order of this, whereby this court said, why can't this petitioner be accommodated, file a report to that
As
extent.
per the prayer of the.
My lord, they record it, my lord.
It is confined to respond number 6 only.
Even if they don't want to file an affidavit in opposition, the order still remains. Right?
That's okay.
So let them contest without an affidavit.
I just appraised it.
India may have to create
May
a
have to
post
create a post. Yes,
Post.
that is the order.
or to make suitable
Let
adjustment.
us record that in
Yes, my lord.
the.
Time to time extension.
It is submitted on behalf of the Union of India that the Union of India does not intend to use an affidavit in opposition in this matter.
Use the fact no release payment.
The matter is otherwise ready for hearing.
Fine.
Paragraph, the matter be placed before the next available circuit bench.
Fine, I'm grateful.
Item 5, working on
Doesn't matter to take it as that because the council sir was handling this, then now I have to go through this document.
There is a difficulty with Mr. Chakraborty also. His appointment has not been
No, I
extended.
know, Your Lordship, because we are at the fag end of the circuit, and it will take time, this matter will take time.
On prayer of the parties, the matter is placed, the matter be placed before the next available.
item 3,
ये कॉपी ले लो.
I've gone through. It only contains the geography and history of Andaman and Nicobar Island and nothing to address the present situation. Before my learned friend Malot starts, Malot, I would just like to indicate few things, Malot. Today, we are not taking the this litigation final disposal. Just for the limited purpose, if some interim directions can be issued to address the present situation, which is affecting the islanders matter. I've just prepared a small note, my lord, I'll share with my friend also. And my lord, the report which has been filed by is my learned right, is not even signed by an officer. If something, please, if something is incorrect, who is going to take the responsibility?
He's on main.
No, this is not the way, you will file in the court.
We will file it not by as.
You should advise your client the manner in which your report is to be filed. You are dealing with the life of the islanders. My lord, I'll just indicate,
has asked us to
indicate
bring out the facts.
short, my
So
lord.
we have been.
And brief notes, my lord. The power requirement, my lord, as on today, let them dispute if they can, my lord, is 53 megawatts. Whereas the generation is 33 megawatts, my lord, there's a shortage of 20 megawatts, resulting in disruption of power supply for about 10 to 12 hours, my lord. Affecting everybody, the students, the people, the old age people, the traders, the students, each and everybody, visiting the hospital. My lord, may kindly come to the third paragraph. My lord, the competence, my lord, of the honorable lieutenant governor for purchase or for tendering is up to 50 crores, my lord. If it is beyond 50 crores, my lord, then it goes to the ministry. So as far as the purchase of generators and all these things are concerned, at the ministry level, there's an authority which I have indicated in paragraph 3, that Central Electricity Authority, my lord. Now, my lord, Central Electricity Authority, my lord, had approved a proposal, my lord, for purchase of diesel generators of 15 megawatts. 9 megawatt at one particular power station and 6 megawatt at another power station, my lord. Now, my lord, when this, after the approval was given, my lord, by the Central Electricity Authority, when the tendering process was initiated and it was moved to the Lieutenant Governor, the office of the Lieutenant Governor, it was returned, refused and rejected by the Lieutenant Governor with an observation that you opt for green energy. But once the ministry had approved it, it was not within the competence and the authority of the Lieutenant Governor to reject the proposal. My first submission, my lord, would be let them produce this particular file before this honorable court tomorrow, my lord, as to under which authority this proposal which is approved by the ministry for.
Not to, we would like to have a response to this,
My lord.
yes.
I'll just explain in slightly, my lord, so that
Details so far as an allegation which is there.
not an allegation, it's a factual aspect.
We have
This
to
ought
clear
to
it.
have been by way of a supplementary affidavit, because I would like them to deal with this, we would
Well-
like, and come back with a proper response.
My lord, I'll just.
So that at least by this circuit, we can pass some orders and go.
My lord,
Because this will continue, it cannot be concluded
it has
here.
to be monitored by my lord.
Absolutely, absolutely. So will you come with an affidavit tomorrow?
Well, I will file it during the course of the day. Give a advance copy to my learned friend, let it appear tomorrow, ma'am.
Tomorrow, I think let it appear on Monday, because it will be difficult for, again, it will be a same kind of a report without any signature.
Undertaking may be taken on record and that I'll be filling it and giving them an advance copy and let them come with a response on Monday, ma'am.
Yes, that's exactly what, huh?
Your lordships,
Monday-
I appear on behalf,
Absolutely,
The order for the
absolutely.
next circuit can.
Yes, yes, yes.
I request not.
your lordships, I appear on behalf of respondent number 6, Seki, your lordships. We would also like to respond, but however, your lordships, it takes more than 2 weeks.
Yes, you're appearing for?
In principle.
Respondent number 6, your lordships, we would also like to respond to the affidavit. However, your lordships, it takes more than 2 weeks for the documents to.
Nothing to
reach.
Who is she representing?
That's
Solar Energy Corporation of India, Lordship.
Yes?
Solar Energy Corporation of India.
in fact, when the matter will be taken for final hearing, Solar Energy Corporation, Mela, they have stated on affidavit that they have been taking all positive steps for reviving the electricity. But the response from the administration is not coming up. The administration is not pursuing, not providing them with the details. In fact, their affidavit is against the administration.
Six solar energy.
Your lordships, we were impleaded, we were not parties originally, we were impleaded by an order of your lordships on 5th of February. After that, we have filed an affidavit. Your lordships, I would just like to point out that though we were responsible for setting up the green projects in the state, the administration has not signed the MOU with us. We have signed the MOU and we have given it to them on 25th of March, but they have not signed it. And your lordships, we have completed all our responsibilities. We have given them the tender, the draft tender.
On affidavit.
When we see the content of the
This
administration.
is relevant. That's why. Madam, will you please come back with an affidavit to this effect by
Your
Monday?
lordships, I have filed my affidavit on 4th of July already, your lordships. The other side had sought time, the petitioner had sought time to reply to that. However, they have not filed a response.
I think that's,
This is the,
Certification, no, those are.
report in the form of affidavit on behalf of the Solar Energy Corporation, right?
Yes, your lordships. That contains the MOU also, your lordships. The MOU is at Annexure 5. Your lordships, I can take you through it. Sorry,
You-
your lordships.
It was not signed by the administration.
It's not been signed, your lordships. In fact, we have been working for the government since 2022, but we have not been paid anything, your lordships. We have still given them the draft tender because we were responsible for that. All the work is complete from our side, but your lordships, the administration has not signed anything with us as yet. And your lordships, for the other projects, they have given us instructions that we don't have to implement the projects anymore. So, your lordships, I'll take your lordships through the affidavit, but right now, your lordships, that is the status. We have stated everything on affidavit. However, if anything is being filed by the other side, we require some time to file a response, and it takes more than 2 weeks for documents to reach from Delhi to be filed in court, your lordship.
with the administration, my lord, as far as these.
And let there be a supplementary affidavit today. We'll request a copy to be served upon
Nothing
you.
against it.
But then please come back on Monday.
Your
We'll,
lordships, yes.
but the allegation is against the administration and not against you. And you have played your part, right?
Yes, your lordships, that's placed on affidavit already.
With a response on affidavit on Monday, please be there on Monday. Let us see how the matter works out.
Very well, your lordships. But on Monday, if any time is required, if any allegations are made against us, if we need to respond, then time may be given, your lordships.
I don't think allegations will be made against you. So please serve a copy to her also in course of this day.
I'll collect her email from.
Yes, please. A brief note submitted on behalf of the petitioner is taken on record. The petitioner seeks to use a supplementary affidavit, including his contention in the brief note. Copy of the said affidavit be made over to learned counsels for the respondents in course of this day. Learned counsel for the administration seeks to use a response to the said affidavit. Paragraph, let the matter appear under the same heading on 11th.
If somebody.
Though there was no written order yesterday, but as my request is honorable court was desirous that.
You mentioned the matter yesterday,
The
actually.
senior officer should be present. An executive engineer, he's an officer with due respect to his status, but he's not a senior officer to assess the code because he deals only with respect to one of the division, not the entire of the department. So a responsible officer, my lord, that's my submission. Rest I leave it to my.
We file on.
Why are you trying?
Satisfy the course and what is the crisis which has been faced by the department? Because it is related to this ministry, not here.
Let us first go through the response. Because it has to be on affidavit signed by a responsible officer, right? We don't intend to the officer physically at the moment. Let us see what response comes.
Okay.
Obliged, your lordship.
Since that's the last day of our service, please be ready with your response and we'll request you to.
Even today, so that I can pursue to the husband.
So that
Yes,
so that 2 days of working days not they can process and they can.
And please serve your response copy also in advance,
yes, absolutely.
so that
Absolutely.
Learned Council is aware of it.
Well, 8 night.
And this file petition yesterday, that had not taken on the lesson level. This is a similar matter, there is a VAT smaller where the VAT commissioner has rejected all the claims on the same date. I think it was on the.
It will be included tomorrow.
Yes. Wait.
The mentioning in the list. For judgment, item number one, WPSP, representation of 2024.
No one for the respondents? Well, the writ petition has been dismissed. The order impugned deals with every aspect of the matter and is supported by sufficient reasons in arriving at a conclusion to dismiss the petitioner's claim. There is no illegality or irregularity in the order. Yes, next matter.
Item number two, here of name on of 2025.
Lordship, I am for the respondent, state lordship, short, just 5 minutes possible, case day is on the wall.
Well,
If the matter would be kept for 12 PM because most probably we'll be signing the MOU today. So if that is done, then we'll submit it before the.
difficulty is after you sign the MOU, that has to be given to the respondents for finding out what is there in the MOU. Come back on Monday.
Monday.
Give a copy to the respondents in the meantime. Let me fix it on Monday. Please come back on Monday.
But we'll notice may come at 12 as well.
You have not signed it as yet, madam.
We are just.
And only on the basis of that, I cannot deal with these matters. The state needs to know about it and what is there in it. The state is a party,
Yes,
What I can
right? And
Can
you
you take up at the end of the list, my lords? We will serve them also. You take a chance.
need to go through it. How do you take a chance? You ought to have given them a copy earlier. And it is not signed as yet.
But
Come back on
since-
Monday.
Since one of the accused is in custody, he is.
I understand. Come back on Monday. It will appear under the same heading. I'll deal with it on Monday. Give them a copy immediately so that they can respond to it.
I'll give it right away, my lords. We'll take a chance at the last, my lords. Kindly call up in the end of the list
It will
because
not take much time.
All
I
the
don't think to
councils
do
are
it
from-
can be, it will be possible. And tomorrow if the state comes and takes time, what is the use? I'll shift it to the next circuit. Come back on Monday. Let the state be prepared.
we will just submit in the last, my lords.
Otherwise,
Let him, he has to take
there
instructions.
are 4 to 5 numbers of.
Let's
cases,
date-
I think all of same.
Yes.
We'll just verify with the date. Let me call in the last, my lords. We will just make a.
Monday, you're not available.
We'll check with other councils also because all the other councils are from.
Very well. Please do that. I am proposing Monday, right?
Kindly take it to the end of.
3 matters, isn't it?
Please, please.
Item number 2 to 5.
2 to 5.
Yes.
Very well. 6. Pass to. Let them come back, yes. They're not sure about Monday, let them come, come back.
Item number 6. WPF 338 of 2025.
One minute. Give me a minute. I've forgotten my specs. It's on the tip. I was wondering what's wrong. Yes, carry on, please. Passover will not be possible. Very well. Thank you. Next.
Item number 7. WPF 348 of 2025.
One hearing for the petition, your lordship. This is with regard to the issuance of transfer certificate. The last occasion, your lordship had asked me to satisfy with regard to the maintainability of this writ petition.
Yes,
Lordship,
since it appears to be a private dispute.
no, lordship. Your lordship, the issuance of transfer certificate here is something which is linked with the right to education. a private institution. even
Sir,
though it is
every action taken by everyone is linked to some right in the constitution or the other.
Your Lordship,
So in that case, there wouldn't have been any private dispute at all.
Your Lordship. Your Lordship, I have a judgment in that regard, Your Lordship. When the school is imparting education, in that case, even though if that particular school is a private school unaided by the government, the school is imparting public function. And when the school is imparting public function, then the school will come under the ambit of Article 226. I place the relevant judgment, Your Lordship. Your Lordship, page number 14.
What are the facts here?
In this judgment also, Your Lordship, the fact is with regard to issuance of transfer certificate.
Other judgment.
Please serve him a copy.
I'll be serving.
He also needs to deal with this.
Your Lordship, para 24, page number 14. Considering the aforesaid judgment.
Here it is termination of service,
Your Lordship, it is termination.
not a transfer
Yeah.
certificate, as you said just
Your
now.
Lordship. Apologies, Your Lordship, in that regard. Your Lordship, here the termination part wherein the private dispute of teachers are involved, that will not come under the ambit of Article 226. But Your Lordship, page number 14, para 24. Considering the aforesaid judgments of the apex court, as also the fact that the appellant is a private unaided institution imparting education to students, which is otherwise a primary function of the state and is performing function public duty, and accordingly it is amenable to writ jurisdiction under Article 226 of the Constitution of India. Further, since action under challenge falls in the domain of public law, the appellant has been discharging a public duty under the prescription of a statute and subsidiary rules made thereunder, that is the Act of 2009, that is the Right to Education Act, and the rules of the state of Madhya Pradesh. The right of children to free and compulsory education, Rules 2011, for denial any rights of his rights in connection with the public duty imposed on such body. Public remedy can be enforced, and as such, and as the service conditions of the respondents have direct nexus of the discharge of the public duty, the fees will be covered under the exception clause, therefore amenable under Article 226. Here, Your Lordship, the relevant judgments of the apex court with regard to the issuance of transfer certificate and dispute involving children and their right to education have been discussed. That is, the apex court judgments have been quoted. KK, Saxena.
Yes, I've seen.
All these things have been discussed.
Please give him a copy, let him deal with it.
Page 24.
Yes, Mr. Shivabalan, can we go into merits?
If there is a private dispute involving the parents, in that case, whether the transfer certificate can be denied or not.
No, that shouldn't be disputed. That is not a ground for refusal of transfer certificate.
Then in this case, Your Lordship, if the respondent school was not even served, without even service to the respondent is.
I've seen that, yes. Yes. So the issue is not, I mean, it is maintainable.
Yes, the matter is regarding job teachers.
Maybe, but the principle is the same.
And why not instruction and something that we are not denied, we are telling that they have to pay the arrears of fees. They have paid, because they are depositing it that.
In regard to the arrears of fees, I have a judgment, Your Lordship, of the Madras High Court. Outstanding dues or outstanding fees cannot be a ground for denial of transfer certificate.
Then how does the school get the fees after the certificate is granted?
Specific civil suit has to be filed, it has been taken. First of all, Your Lordship, the DC, Your Lordship, the particular minor here, that particular minor studied KG1 in that school, that is the respondent school. The classes got over. For the semester examination fees, everything has been paid. Now she has come to a different school in KG2. She has
So
got-
there are no dues.
There are no dues. They are not even explaining the dues which exist.
Monthly tuition fees they have to pay for the period they have
Studied.
studied there.
Yes, he says there are no dues.
There is a due, lots of dues.
You have the documents to show that you have cleared all the dues, the tuition fees, etc. You must be having receipts for the same.
At this stage, that was not told me before. They are, what the school authorities are saying in the petitioner is, because the father has objected and the application is lying for this period, therefore for that thing we have to pay dues. Lordship, para number 26. Para 26, inner page 60. Also, harassing children over non-payment or delayed payment of fees amounts to cruelty and constitutes an offence under section 75 of Juvenile Justice Act. The schools have every right to initiate appropriate action for recovery of outstanding fees, if any, from the parents in accordance with law. Rest is with the Juvenile Justice Act. That cannot be a ground for denial under right to jurisdiction.
This is a different issue altogether. The appellants are directed not to insist upon production of transfer certificate by a child at the time of admission. Please come to,
That was one more issue. What has happened in this particular case is, the earlier school did not issue transfer certificate, the new school did not let the minor carry out continue the class. So what has happened here, the new school was also ordered that you cannot stop the minor from attending the class. That is also one of the issues which was decided. But here, the new school, here in this instant case, they are just asking. They are asking so as then only the minor will be allowed to continue the class.
yes, Mr. Shidwan.
And we are ready to give subject to payment of our legal dues. That's all.
Please see this judgment. You can take
Yes.
necessary steps. In fact, I think let him come back with instructions
Yes,
tomorrow,
correct.
because he has just been handed over.
My lord.
In the meantime, let the dues be also told to the petitioner so that if at all if any.
Yes, if it is minimum amount, I will let you
They
know.
are ready to clear the
I will
dues.
come up with the total amount dues. Obliged.
Heard learned counsels for the parties. At the outset, comma, the issue of maintainability of the writ petition is required to be dealt with. Paragraph. Learned counsel for the petitioners has placed reliance on a judgment. This is a Madhya Pradesh judgment. Of the High Court of Madhya Pradesh at Indore, in writ appeal number 1619 of 2022, wherein the learned court, wherein the Honorable Court has referred to several judgments of the Honorable Supreme Court in arriving at a conclusion that the school, comma, despite being a private unaided institution imparting education to students, comma, is amenable to writ jurisdiction under Article 226 of the Constitution of India, since the duties discharged by the school fall under the domain of public law. Paragraph. On merits, learned counsel has submitted that, before that, in view of the above comma, it can be held that the writ petition is maintainable in its present form and prayer. Paragraph. On merits, learned counsel for the petitioners has submitted that has requested a direction upon the, please strike out the submission submitted, but has requested a direction upon the, this is the second respondent, right? Second respondent to issue transfer certificate in favor of the child at the earliest.
First respondent number one.
The first respondent. The petitioners agree to clear the dues of the school, if any, upon being informed by the school. So why are you asking for the dues, sir? Once you ask for the dues, that indicates that you will clear them. Please strike it out. A paragraph. Learned counsel for the respondents, submit that there are certain dues which are required to be cleared by the petitioners. Learned counsel seeks to take instructions in this regard. Paragraph. The matter is adjourned for the day. Tomorrow, please come prepared. Judgment file. Next.
Item number 8, WPN 356 of 2025.
On prayer of the petitioner, the matter, it's a short matter. Is it a short matter? On prayer of the petitioner, the matter is adjourned for the day. Oh, you're the respondent. Who is the petitioner?
I'm waiting for a short pass over, Your Lordship. I believe there is an interim order.
Come back tomorrow.
Lordship.
She's asking for a day's accommodation.
Interim order, if any, be extended.
She's asking for a day's accommodation. It'll.
That order was for demolition, Your Lordship.
Is it till today?
Your Lordship, it was till yesterday. Yesterday also this matter was heard. The order was in 6th of August.
Yesterday also you sought a day's yesterday it was the petitioner's prayer.
The last petition is already ordered that the respondent authority shall not take any steps in regard to the survey number B. This occupied by the petitioner. However, the respondent is at liberty to implement the order in due respect of survey number.
Yes, so there is no time frame. There is no time frame with regard to this. Let it appear tomorrow. On prayer of the respondents, the matter is adjourned for the day.
Right.
Next.
Item number 9, WPN 339 of 2025.
Your Lordship, by review of the petitioner. Here the petition happens to be a widow. And she's having no issues. Now her husband was a government servant. He has left certain amount in the bank, concerned bank, Punjab National Bank. And that amount, when she went to withdraw that amount, it was told by the bank authorities to bring succession certificate. Because in the nominee, someone else name is appearing who happens to be his brother or cousin or something else. So she has approached the concerned court, obtained a succession certificate, went there and produced the succession certificate. Now they have issued a letter, Your Lordship is astonished to see they're asking her to bring stay order that we should not release in favor of the nominee. That the
Otherwise, the nominee is entitled.
nominee is entitled, but
That has to be stayed
yes,
by the court, by the relevant court.
succession certificate was obtained here. Now, so after succession certificate, they are telling that you bring an order of stay.
When there's a nominee, the bank is bound to pay the amount to the nominee, right?
Yes.
without any kind of verification.
But the.
Because the nominee has been appointed by the person himself, the deceased.
Yes, but we make a paper publication, it's a government press, we have made a paper publication, kindly come forward who requires the amount. So those are things have been adopted by the trial court. In spite of that, they are telling that, no, you have to kindly come.
Have you served? You are appearing for the bank?
I am waiting to go to them.
Banks stated page.
Today we have filed local authority for 10 for filing affidavit in opposition.
You want to come back with an opposition?
Yes.
Till then, you'll also buy some purpose, not to release, direction upon the authorities, not to release the amount. The non trial was there, your lordship. She made a paper publication, no one came forward. The bank themselves have filed an affidavit seeking, saying that, please bring that.
How can this court director stay in favor of the nominee?
Yes.
To the bank, not to release.
Yes, the bank has to. Why? What is the, I mean, legality in that? The bank will release in favor of the nominee, whoever he is. Here you say he's the brother, even if he's an outsider, if he's the nominee, bank has to release.
But there should be some claim at least.
Nominee is there. Nominee is there, but they did not participate.
You have not impleted the nominee also.
I am not aware of who is the nominee, they should tell me, because I have made them as a party in the trial court, and in the trial court, they have given an affidavit.
You have made them a party in the trial court, so you are aware who it is?
No, I have not made nominee as a party, because I am told by them that some brother of the deceased person, but I am not aware.
No.
I made Punjab National Bank as a party to the trial court,
But that is.
and I made a publication to that effect.
Since the nominee's rights will be affected by your writ petition, the nominee needs to be made a party.
So let them disclose his name.
Yes, yes. We give the name
By today?
by today.
Learned counsel for the petitioner submits that the petitioner is the widow / sole heir of deceased like Ali. Like Ali. The deceased had an account with the respondent bank. Stop. When the petitioner approached the bank for withdrawing the amount left behind by the deceased, she was informed that some other person has been made nominee to the said account. Nominee in respect of the said account. The petitioner is unaware of such fact. Paragraph. Learned counsel for the respondent submits that he shall provide the name and details of the nominee to the petitioner in course of this day.
Yes.
Paragraph. On prayer of the petitioner, liberty is granted to implead the nominee as added respondent in the writ application.
Till then, you know,
I cannot, no, that will be an illegal order. The nominee can take action. He has all the right to, you have to fight it out with the nominee. If it was some outsider who is claiming, there could have been a stay order. The nominee was appointed by the deceased. There is no dispute. The trial court has dealt with it. So at this stage, I don't think I can stop the now. The matter will be placed before the next available circuit bench. Then you're lucky if there's no one there, no one claiming. And I'm afraid once you serve, it will be claimed. So serve it immediately at the next circuit so that you have an avenue open.
Number 10, CEO Quarter 6 of 2025.
I for the petitioner.
I received the copy, Your Lordship. This is another case where the widow, she has claimed the death benefits of her husband. They obtained an order from the honorable court, despite communicating that order, and the order was never challenged by the other side. And now they have stopped me.
The factual aspect is that, my lord, the opposite party responded over here. She filed a case before the honorable district civil justice division saying that she was a second wife. She is entitled.
She was the second wife.
She should be declared as a legally wedded wife, and subsequently she made another plan that the pensionary benefit has to be released to her.
Yes.
Pensionary benefits
Oh.
has to be released to her. the Honorable Civil Court has passed a decree whereby it has specifically said that she is been declared as a legally wedded wife. And subsequently, a pensionary benefit has to be released. In terms of the pensionary rules, that was the decree passed by the Honorable Civil.
Yes.
But the authority is not against the decree. The difficulty is she has made in the service book in the year 1997, the deceased, the government servant deceased has incorporated the name of Sushant being as a wife.
Who is that?
That's the first wife. And it was continued throughout till his retirement. When she himself made a complaint saying that he will get all the benefit, he will leave this island, so I will be left with no money. So she made a complaint also saying that he has given the name of Sushant Stella, Sushant as his first wife. Rather, he has affixed my photographs in the pension book. Then, after a few months, she again filed an application saying that I will withdraw my objection. Let the pension be sanctioned in favor of the first wife. It is done. That's why I'm pointing. She has made this. Now, after that, when we processed, then again she filed that's a decree has came into existence. We have pursued based on the decree. Now the parent account authorities are asking the death certificate of the first wife. We asked her to produce the death certificate. She is not producing.
What has happened to the first wife? She has expired.
That is nothing.
She expired. According to her, she expired.
According to her, that is a difficulty.
He was a government servant. That way.
My lord, if the decree, my lord, will comes once, it says 1986 she expires. But 1997 in the service details, the deceased government servant has incorporated her name to be as a nominee in all the papers.
Will you come back with the documents? These documents are required to be seen by you also, I believe.
Wait, this is a.
With regard to that, I filed an application under section 47 of CCC. These are documents. I can file it.
47 was turned down, I think.
Turned down, Lord. It has not been attributed on any issues which I have raised. Nothing has been discussed by the trial court.
And you have not challenged that order?
That order I challenged by the civil reason.
Yes?
That order I challenged with the lordships. Section 47 order.
Oh, you are the petitioner here.
Yes, sir.
Yeah, 114 नहीं है क्या थोड़ा सा?
You did not contest the.
No, the department has not contested a suit.
This observation, judgment debtor has failed to show that such second wife, you are the second wife.
It's wrongly written. Ought to have been
It is also wrongly written, but there's a second one.
first one.
Have you annexed all these documents?
So far as the relevant documents, I have enclosed at page number 70. But subsequently, when she himself has wrote a letter on 21/9/2006.
Yes, please, where I have you annexed those letters?
Lord, kindly come to page number 70.
70.
Yes, sir.
Categorically denied in my case here.
No, these are.
Trial court.
No, that has not been brought in the knowledge of the trial. Lord, may kindly see, Lord, in the judgment which is passed by the trial court, it is mentioned 22/11/1983, she was expired. But the government servant Biraj Bakra himself on 14 May, his wife Srimati Soshan in contract of, so she given declaration when she is expired in 83. Why should a government employee give a declaration in 1997, my lord? That is the one
That
aspect.
she is the wife.
She is the wife. And my lord will see the.
Are all these documents on record?
No,
This,
this was not there before the trial court.
Lord, this has to be adjudicated out of 47, my lord. That's why I made an application before the courts. Because, my lord, we not against anybody.
Brought these documents before the court, executing court in section 47.
Yes, my lord, I have enclosed. I have enclosed this along with the letter of objection.
Enclosed.
But not here.
Nothing has been discussed by the trial court, my lord. Lord, it should have been taken cognizance of these documents and it should have adjudicated. He has only said that, and that to be a finding that the first 5 details has not been furnished.
They are just asking the death certificate of the first wife.
But it will be
Here
clear
also
issues.
made a paper publication, if she was alive, she would have come in. So no one claims.
You are not able to get hold of the death certificate.
She's an illiterate lady, you know, but this man happens to be a chronic alcoholic person.
Do you want to file an opposition to these documents? Because these documents in fact goes against you. Like once you file an objection, then you withdraw the objection, admitting.
She's an illiterate lady.
Lord,
They have a problem.
Maybe you have to explain that.
Explain it by way of
By way of
my written objection.
before the executing court, right? Come back with an affidavit in opposition, I think. You have all the documents or you need a supplementary
I
affidavit?
just need these 3 letters, my lord. I file it by way of supplement.
So I'll allow you to file a supplementary affidavit because, and please file a comprehensive response to this. Give her a copy, please. On prayer of the petitioners, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the respondents seek to use an affidavit in opposition in this matter. Affidavit in opposition we filed within 1 week. Opposition within 1 week. Within 1 week from date, stop affidavit in reply, comma, if any, comma, be filed within a week thereafter. The matter be placed before the next available circuit bench.
Obliged.
Please exchange your affidavits in the meantime so that it can be dealt with.
WPA 290 of 2025.
Time for official respondents.
Anyone appearing for the private respondent?
And the traffic court that comes from legal that is also on July 14, the something was delivered to the practice.
Served.
Yes, sir. July 14, the item delivered.
Yes. Yes, what is the matter about?
Page 31 of the petition. Passed by the Tahsildar Paragraph.
Yes, yes.
Now, you have to, this notice has been issued on the basis of a order passed by the Honorable High Court, Your Lordship, in WPA 174 of 2025, filed by the private respondent here. Now, Your Lordship, in that matter, I was not a part. Now, Your Lordship, you have to see, the order was to the effect that the private respondent has to make a press representation to the Tahsildar concerned for the application. And the Tahsildar concerned in accordance with law has to initiate a review phase thereafter. And after including the review phase, the Tahsildar concerned has to issue notices to all the concerned affected party. Now, in this case, Your Lordship, you have to see, the order was passed on 24th March 2025, the petition. May I read the order?
Yes.
Whereas the Honorable High Court at Calcutta Circuit Bench at Courtware passed an order dated 24th March 2025 in the matter of WPA 174 of 2025, Timothy Ruby versus the Tahsildar, will be the private sound. As the gist of the order passed by the on photo. As the petitioner grievance is only with regard to demarcation, the present petition can be disposed of by permitting the petitioner to apply before the concerned Tahsildar for demarcation of its property. If any application is made by the petitioner within a period of 4 weeks, from date, the concerned Tahsildar shall, after consulting the record
And if it is found that the property is disordered in the name of the petitioner, shall demarcate the petitioner's motion in accordance with law after notifying and giving an opportunity of hearing to all interested parties.
How are you affected?
Now, your lordship, without any notice, without indicating any immediate, your lordship, all of a sudden, this notice has been took to me.
How are you affected? This is issued to you.
Yes, your lordship, issued to me, and under the discharge of this notice, they entered into my land, your lordship. This is the thing they have done, your lordship. First of all, as per the Honorable High Court order, the Tahsildar has to receive a representation from the private.
You were asked to appear before the Tahsildar. Did you appear?
Yes, your lordship, I appeared, your lordship.
What has happened after that?
By this notice.
12th April, you were asked to appear before the Tahsildar, right?
And now you kindly appreciate. Hence, issue notice for demarcation. Now, your lordship, what representation the private respondents made?
Have you submitted an objection to this
Yes,
notice?
yes.
Where is it?
That's page, your lordship, starts from page 33. 33, prior to that also, I made representation of. 33 is there, my advocate notice, your lordship. And prior to that, page.
This was issued to Jeevan Singh. Jeevan Singh, you are the daughter. This was issued to Jeevan Singh.
Even seeing your I'm the daughter, even see expired here. Time and again, it is beginning, the notice was put to other different survey numbers in the name of Given Singh. I used to make representation stating that Given Singh expired, we are the legal as finally serve notice upon us. But they never done. All of a sudden, you know, this in the protecting compliance of the also High Court's order, this act has been done by the Tahsildar concern and revenue staff in collaboration with the private respondent here, and they entered into my land and tried to demarcate my land, your lordship, without any permission. So, and the first instance, this honorable court needs to pass and stay out in the model of this.
But you said that the demarcation has been done.
So they tried to do demarcation and which
You resisted. Page 33 is not an objection to the demarcation. You asked for initiating appropriate proceedings. There should be initially an objection against this demarcation notice. Where is that?
This demarcation
Notice, yes.
So this demarcation notice, I only.
This is a complaint against the revenue inspector and the.
In that, I have made objection regarding the.
Cannot be. You have to make an objection before the authority who has issued the notice, the Tahsildar. That's the first step, isn't it?
Yes.
This is to the Lieutenant Governor, etc., etc. But where is the objection filed before the Tahsildar?
Copy not given to Tahsildar.
Forget about copy not being given. You have not. Yes, you have not filed any objection before the Tahsildar. That is not an objection. That's a letter directing initiation of proceedings. Yes, let us hear the administration.
My lord, this notice is issued pertaining to the survey number belonging to the private respondent 1/5. Whereas the petitioner's survey number is 1/4, 127, 128, 196.
You issued a notice to him, the petitioner.
My lord, no, notice is not issued to the petitioner.
It's issued to the petitioner's father.
Yes, my lord, because the
Same
adjacent plot holders for their attendance, it has to be, it is as per the regulation, we have to issue the notice on the four boundaries. So the one of the survey number comes under the.
He is one of the
neighbor,
yeah, one of the neighbors. Yes,
that was
adjacent tenants. Yes.
Yes, only that purpose, because in compliance of the High Court order, they have applied for demarcation and we have issued the demarcation notice. And
Is
we
the
have.
demarcation complete?
Yes, my lord, we have after the. Yes. Yes, this is the report.
That they have given notice to the house of the party.
You have received notice.
Yes. Yeah, filed.
If the Honorable High Court directed the private respondent hearing to file a representation before the Tehsil concern. Let them show that the representation in compliance of the Honorable High Court order was filed by the private respondent.
That is
They have
between
to-
the Tehsildar and the private respondent. How are you concerned?
Later on, later on in the order of the High Court, it has clearly stated that after the receiving of the application by the private respondent,
Yes.
the affected party is to be given notices and hearing, affected hearing, Your Lordship. In the regulation, Your Lordship, any application is made before the Tehsildar. Tehsildar is bound to issue, bound to start a revenue case, Your Lordship. See, in the page 31, the top.
In that case, I think an affidavit in opposition should be
Yes,
invited.
We'll file opposition.
My interim order.
There was an interim order already.
We'll file.
Affidavit of service filed by the petitioner is taken on record. The private respondent is not represented despite service of notice. Paragraph, learned counsel for the administration seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks.
My lord.
Within 2 weeks from date. Stop affidavit in reply, comma, if any, comma, we file within a week thereafter. Paragraph, the matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 31st August 2025 or until further orders, comma, whichever is early.
Oblige, my lord.
Next.
Item number 12. WPL 359 of 2025. Lordship, I am appearing for the respondent to Lordship has filed a similar order. This similar order can be followed for the WPA number 334.
But application has been filed. Application has been filed for electricity. That is pending.
Yes.
Yes, what is your case, madam?
Lordship, WPA number 54 of 25.
That I do not have with me. Let me pass an order here. Where is your application?
Page number 10.
Third learned counsels for the parties. The petitioner filed an application before the respondent seeking electricity connection in her premises. Filed an application before the respondent on 7th March 2025 seeking electricity connection in her premises. No notice was also issued. No notice was also issued. The application is lying with the, nothing has been done with regard to that. The application has not been considered and electricity connection not granted to the petitioner. Paragraph, upon consideration of the submission of the parties, comma, this court directs the respondent to consider and dispose of the application submitted by the petitioner dated 7th March 2025 and further consider grant of electricity connection to him subject to the petitioner complying with all the requisite formalities, comma, in accordance with law. The writ petition being WPS law within 2 weeks. Within 2 weeks from the date of communication of this order. Disposed of urgency referral. Next.
Item number 13. WPL 386 of
Yes.
25.
Lordship, here I will use my opposition. Lordship. This is second round litigation, Lordship, so. we have already
Second
filed-
round of litigation.
Similar order was passed by the Honorable Court to consider the requisition of electricity.
Yes.
After that, the similar order which Lordship page number 33 Lordship. Passed by Honorable Justice.
33.
Yes, Lord, 33. After that, Lordship.
This was a direction for this
Yes, yes.
consideration of the
After that,
representation.
okay, Pages 35 and 36. A note was sent by the electricity department that I am already having a electricity meter which is in an watery tsunami shelter. And after that, there was a legal opinion by learned counsel Tulsi Laskar, in which it is written that one Srimati D. Jamuna having date of birth this, as such, my client also falls in the same category as that he may not be given electricity. Kindly appreciate Lordship, that there is nothing to do with that petitioner P. Jamuna with the present petitioner Babu Sarkar. I am just praying for electricity, Your Honor. And for that.
Lordship,
correct
let me use the opposition, Lordship. I will clarify the position.
Learned counsel for the respondents seeks to use an affidavit in opposition in this matter. Paragraph affidavit in opposition be 1 week. 1 week.
Lordship, 1 week it is not possible.
2 weeks.
2 weeks.
Affidavit in opposition be filed within 2 weeks from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. The matter be placed before the next available circuit.
Obliged.
The passed over matters.
Over matter. Item number 2, here, 535.
Yes, is your MOU signed?
Yes, please. My leadership, we are deeply grateful for the kind indulgence. And because of this indulgence only, my lords, this was possible.
You need to serve a copy to the state.
My lords, we have done so.
I received the copy, very manner just received, I got read out the entire.
Yes,
Fact.
Can I place it on record?
should be by way of an affidavit. You
Because
cannot
we have
fix it up
notarized it, my
like
leadership.
this. Should be by way of a supplementary affidavit.
We are getting that, we'll do it in the course of the day, we'll file it. Yes, my leadership.
So let us deal with it tomorrow.
Tomorrow? Fine, tomorrow, my
You
lords.
cannot submit a document.
My
like this
leadership,
to the
yes,
court.
fine, tomorrow.
And I believe he has to take instructions also.
The complaint authorized persons or not, and to verify so on. Who the property will be done.
Ought to have served an advance copy to them. I understand you're coming from outside, so that's why I'm saying this.
You got assigned mallards today, just about half an hour, 1 hour ago. Mallards.
Because of one of the person is actually behind bars.
So we had to wait for him to come. In the course of the day, we would file the affidavit.
It may be recorded, my leadership.
Procedurally.
No, not only that, he needs to take instructions. He says, I've just received the copy.
On the PP.
The parties are separate here. It's a matter, the parties are separate.
The very important issue is whether the parties can settle. That has
That's
to be-
leadership. I think let him take instructions on this and tomorrow we can get it done. Upon the
Yes.
instructions received.
My lords, considering this MOU, my lords, if in item number 2, my lords, in Mohammed Basim, you've moved to 439. For this MOU, my lords, at least there could be a stay on arrest or at least he may be.
He's already arrested. There cannot be any stay on arrest. That could have been prior to his arrest, not now. Come back tomorrow.
My lords, because
I have to deal with the matter on merits, not on this.
Leadership will deal with on the matter.
Come back tomorrow.
then the matter.
You'll come back with a supplementary, yes, it will be. Learned counsel, so supplementary affidavit in the CRRs, right?
Leadership.
Not the bill.
If the affidavit is filed in the CRR, they are all 482 petitions. And
Consolidated ones, right?
They are
Can be taken consolidately.
so
How can a bail petition be consolidated with CRRs?
The bill, just the
CRR.
CRR leadership. Only the CRR.
Orders for today. Learned counsel for the petitioner seeks to use a supplementary affidavit annexing the memorandum of understanding executed by and between the private parties. Paragraph, the matter is urgent for the day.
Meanwhile, people will take instructions also, my lords, if we can we come on the call.
He has to.
Yes. My leadership, if I may request for a fixed time if possible, so that we can get our tickets accordingly. I'm so sorry, I know,
Yeah.
it's asking for too much.
শুরুর দিকে রাখুন তাহলে। It will appear at the top.
At the top, I'm so deeply grateful, much obliged, much obliged.
You can go back in the second half, I think. Let me see if I can deal with it in the first half itself. Yes, 6.
Very innocuous. My representation is pending before. After this, please. Let it directly be given upon them to.
What is the representation about?
Upgradation of online record books. On instruction and submission. The subject line, because the division bench. And this honorable division bench has already also stayed.
Stay on?
Stay on there, there is an eviction order.
No, what is the prayer here?
By airport authority. And there was an eviction order again. There was stay and eviction order in respect of the subject.
Here, she seeks necessary correction.
Necessary correction in respect of that subject land.
Yes.
Whether that subject land is still a government revenue land or it has been allotted to.
So a representation is pending before you. Why don't you dispose it off? It can be a yes or a no. Right?
Yes.
I'm not asking you to allow that. You have to dispose it. Where is the representation?
It's a page number.
If you feel there's a division bench order, etc., you can always turn it down. Should be disposed of. You cannot keep it pending. You are for the airport authority.
I'm for the airport for.
Deal with all that and dispose this off. That's all. I'll not direct anything else. Since the
All interest.
strike it. The innocuous prayer of the petitioner is for consideration of a representation submitted
Various date, the last one was 14/6/2020.
by him on 14th June 2025 before the first respondent, right? Before the first respondent. Upon consideration of the submission made on behalf of the parties, the first respondent is directed to consider and dispose of the representation submitted by the petitioner dated 14th June 2025 within 1 week?
No.
2 weeks. Within 2 weeks from the date of communication of this order, upon giving reasonable opportunity to all concerned, including the petitioner, in accordance with law. Paragraph. It is made clear that this court has not gone into the merits of the case and the first respondent shall be at liberty to deal with the representation independently in accordance with law. Since no affidavits, urgent certified website.